Thank you for waiting. Now, we would like to start a panel discussion. So now I'd like to introduce panelist, moderator and panelist, Mr. Morifuji Atsushi, Chief Judge, Trial and Appeal Department, Japan Patent Office. Panelist, Dr. Michael Tierney, Vice Chief Judge, Patent Trial and Appeal Board, U.S. Patent and Trademark Office. Panelist, Dr. Ingo Beckedorf, Chair of the Legal Board of Appeal, the Board of Appeal, European Patent Office. With this panelist, we are holding panel discussion. The panel discussion consists of the two sections, the first and the second sections. The theme of the first section is the oral proceedings, and for the second section, determination of inventive step in the hypothetical case. The hypothetical case is the same as the one we had in the mock oral proceedings earlier.
JPO conducted a mock oral proceedings of a patent invalidation. We will start a discussion on this oral proceedings. JPO, USPTO, EPO. Each office has trial and appeal system. Under such trial and appeal system, I heard that sometimes oral proceedings or hearings are conducted. There are 3 questions from question 1A to 1C. Under each office's main trial and appeal system, which do you conduct, documentary proceedings or oral proceedings? This is a question 1A. If oral proceedings or oral hearings are not necessarily conducted, how is it decided whether to conduct oral proceedings or oral hearings? What is the ratio of documentary to oral proceedings under the main trial and appeal systems? Please answer the percentage of oral proceedings and oral hearings. This is question 1B. Question 1A and 1B are related, so we appreciate it if you could answer that together. First of all, Mr. Morifuji, Executive Chief Administrative Judge, would you kindly give us a view? JPO's main trial and appeal system regarding the patent includes appeal against examiner's decision of refusal, trial for invalidation, and opposition to grant of patent. I will answer from this viewpoint. For appeal against examiner's decision of refusal, in principle, we are conducting documentary proceedings. For trial for invalidation, we conduct proceedings in principle. It's oral proceedings. So for 1B, so in either case, by a request of a party or ex officio, it is possible to adopt a trial method differs from the principle. So when we do the investigation searching, oral proceeding is assumed. Between 2022 to 2023, for 2 years, 154 cases of invalidation trials were decided, and about 95% of those, or 146 cases, conducted oral proceedings. Also, during the same period of the appeal against an examiner's decision of refusal and opposition to grant of patent, there were no cases of conducting oral proceedings. Everything was writing. This is my reply for 1A and 1B. Thank you very much. Now I would like to ask Dr. Tierney of USPTO.
Yes, thank you. So we conduct oral hearings in both appeals and in trials. And we're very similar to the Japanese in our statistics, and at our trial proceedings, almost every trial we conduct will have a hearing. Conversely, though, for appeals, only 9% of our cases actually have a request for an oral hearing. Now, the reasons can be a little bit different. The record in the trial is much more extensive, and the parties want, because of the economic interest in the trial, they tend to want to come before the office and present their case and try to answer any questions we have. So in a trial, we generally give an hour each side for a trial hearing. Now, if they need more time, we're open to having more time. If there's a complicated case, we can have it go on hours, but generally we don't go into a second day. The most we'll have is when you have 4 or 5 patents being challenged, you may take a full day potentially, and complicated issues. Oral hearings in the appeal side, though, are very focused. It's more or less 20-ish minutes. You can go a little longer, but it's much more focused because the record is much more truncated. It's a much more simplistic record, and the issues are much more focused than you have in a trial, which is because of the voluminous record you have, there's many more issues that need to be covered. So I think we're pretty close to what Japan has, and I'm looking forward to hearing what the EPO has.
Okay, thank you very much. In all proceedings under the EPC, and those proceedings concern both the proceedings before the administrative departments, examining and opposition divisions on the one hand, and the proceedings before the boards of appeal in appeal, they are governed by the same law, and this provides that which allows for both written proceedings and oral proceedings. There's one particular article in the EPC, that is Article 116.1, which gives the party the possibility to request oral proceedings. Again, this is applicable both before the divisions, administrative divisions, and before the boards of appeal. Or the board, and that's the same as I heard before, the boards may also, and the divisions may also, ex officio summon to oral proceedings when the division or board considers this expedient in the case at hand. Now to the ratio. The ratio depends very much on the type of proceedings. In what I call the ex parte proceedings, i.e. the proceedings with only the applicant before grant, or the proceedings before the boards of appeal after refusal of a grant. Here we have in examination, before the examining division, we have a very low number of oral proceedings. The ratio is less than 90%. Why? Because the examiners tend to get directly in touch with the attorney, with the applicant's attorney, in a kind of interview, and open questions are settled in that way, or in writing, and then usually the party either does not request oral proceedings or withdraw the request. In inter partes proceedings after grant, opposition divisions or boards of appeal, there the ratio is a lot higher. In opposition cases before the opposition division, it is, I have to check it again, it is almost 100%. There are only few cases. In the boards of appeal, we do not distinguish between the two, but we are around 50%. But these 50% are higher, or it's a higher rate in opposition appeal cases than in examination appeal cases.
Thank you.
The next question. In each office, what is the purpose of conducting oral proceedings at your office? What is the advantage do they have over documentary proceedings? Now, Mr. Morifuji, please. I'd like to answer the question. Now, the purpose of these oral proceedings, the purpose is to accurate understanding of the issues and technical content and speedy hearing. First, prior to the oral hearing, the panel will send a notice of matters to both parties. And notice of matters will contain a specific statement of the issues to be resolved by the panel regarding the parties' claims, as well as the panel's tentative position on the issues. The parties will therefore argue and prove only the necessary issues at the oral proceedings. This makes it possible to conduct efficient hearings. In addition, during the oral hearing, the panel will be able to obtain a more accurate understanding of the technical details by receiving the parties' explanation in person. In addition, at the oral hearing, the panel asks questions to parties to encourage them to prove their case. This hearing enables the panel to elicit arguments from the parties that cannot be fully expressed in writing and to ascertain more precisely the issues in dispute. Then, the party may orally refute the opponent's claims. This may make it unnecessary to submit written answers or written rebuttal, which needs to be submitted if in the case of the documentary. So the proceeding will be shorter in time than the documentary type. So at the JPO, there will be an exchange of the opinions at the oral hearings, and it will take 1.5 to 2 hours for each of the oral proceedings. When it comes to the complicated cases, maybe it will take half a day or more in the oral proceedings. So this is my comments. Thank you very much. And now, from EPO, Dr. Beckerdorf, please.
Okay, thank you very much. The purpose of oral proceedings is mainly to wrap up the case, to bring it to an end, because the idea is that at the end of the oral proceedings, the board or the division issues its decision. That issuing of the decision means expressing the order. In examining division, whether to grant or not to grant. In opposition division, whether the patent can be maintained in whatever form, or whether the patent is revoked or the opposition is dismissed. In an appeal, it is about the appeal, and it might be a cross appeal. It might be appeal by all parties, one patent proprietor and up to 20, in some cases up to 20 opponents. So the idea is that although the focus lies on the written proceedings. I mentioned this earlier, that we have a system that we call front-loading, by inviting all parties to make their case, to state their case at the earliest possible moment, in particular in appeal, with the statement of grounds of appeal and the reply to the statement of grounds of appeal. Nevertheless, the purpose of the oral proceedings is, after having been informed of the board's preliminary opinion, in a communication that I mentioned earlier as well, under Article 15.1 of the Rules of Procedure, that the parties can react by making the board aware of potential needs to correct views, or having made some incorrect assumptions, or to highlight the main points. It is not the idea of the oral proceedings to plead the entire case, and it's not the idea to amend the case. This is only be possible under very, very strict circumstances, but it is the expression of what we call, laid down in a different article of the EPC 113, to give the parties the right to be heard, so that they have the last chance to state the case. That again, this is a bit different when it comes to the length. Different depends upon the nature of the proceedings. In ex parte cases, it may be an hour or even less. In inter partes proceedings, usually it takes, let's say, 3 hours up to several days, depending upon the case. In pharmaceutical or biotech cases, it may take 2 or even 3 days to give this right to give all parties the right to be heard to make their case. Thank you.
Yeah, at the USPTO, at the PTAB, generally as we are the same in that our evidentiary record is closed by the time we get to a hearing. So you've already got all your documentation in the case, you've got all your arguments. There are exceptions. Once in a while, if necessary, we will have an inventor or somebody come up and speak and be cross-examined at our oral hearing, but that's not the typical case. Typically, our evidentiary record is going to have an expert on each side. They'll be cross-examined, and we won't have them come before us. We'll have the evidentiary record in writing, and we don't really need to see the expert testify as to their technical details, we can more or less read them in the documentary record. So the purpose of the hearing is to more or less for the attorneys to come in and explain their case and basically try to focus our attention on what they believe to be their strongest points. That said, the other part of the hearing is to answer any questions we have. So what happens often is, for example, in our trial hearings, we'll have a party come with, say, even though they're only speaking an hour, they may have 150 slides in a PowerPoint. They don't intend to get through all 150 slides. What they intend to do is start talking, and to any question we have, they can then go to that part of the PowerPoint to then show, oh, and the evidentiary record shows this in response to your question, Your Honor. So what they've tried to do with their presentation is be flexible and be able to answer what they expect to come up. Once in a while, they get questions that they don't expect, and then it becomes a little more interesting, shall we say, at the hearing. There are a few times where they don't answer our questions, and one of the things we always tell people is to try and answer the best you can and don't just dodge the question. If it's a weakness in your case, try to answer while you think it's not necessarily a weakness or how you can refute it, because if you do give us a non-answer, I've actually had a colleague who has said, let the record show the party has not answered the question, and put that into the record. For purposes of appeal, when our appellate court looks at it, they then see right in the transcript that the attorney wasn't answering any of the questions at the hearing, and so it's not a very good look. And so our point is, if the board asks questions, you're there to answer them. And that's the purpose of the hearing, because you want to have our questions answered, because when we go back to write up the case, you want us to be able to go, okay, they want us to look at evidentiary record, exhibit 1001 to whatever it may be. Also, when we have questions, just to let you know as an audience, sometimes I'll ask questions because I think something is weak in your case. Sometimes I'll ask because I think it's strong, and I want to know what you are going to say if you have to appeal it to the Federal Circuit, to our appellate court. Because I want to know, can you actually defend us if we actually rule in your favor? And conversely, if there's a weakness, I want to know, am I on the right track in believing that this is a weakness? And then maybe they don't have a strong answer. So that's what I view as kind of the purpose of the hearing.
Dr. Tierney, thank you very much for your answer. So we have collected all the answers from the different boards. Judge Morifuji, how would you like to handle? Thank you very much. So listening to you, and also based upon the comments that we have received so far, we have made this summary. So the first part, the ratio between these two has been mentioned. So this percentage are okay for you? These are from your previous answer. So USPTO, 9% of the peers. USPTO, 9% is mentioned here. Is that correct? And for EPO, 6%. Or did you say 50% or 60%? 60% is the oral hearings. So based upon the request from the parties, you have the oral proceedings. So the purpose of the oral proceedings at USPTO, the explanation by the parties and the Peter asking the questions to the parties, those were the important points. And also EPO emphasized the importance of the right to be heard on the part of the parties. So that is very important. So to give you the space for the both parties to speak is very important. And also the EPO, at the time of the end of the oral proceeding, you have the final decision. And JPO does not offer any conclusion at the time of the oral proceeding. So the panel will make the judgment and decision later on. So I have a question to Dr. Bekadov of EPO. So at the end of the oral proceeding, you will offer the final decision. The panel will give the final decision at the oral proceeding. Isn't it difficult or easy? So how the panel has to be prepared if they go to the oral proceeding so that he can make the final decision at the end of the oral proceeding?
Thank you very much. First of all, a board usually meets before the oral proceedings, the day before or on the day of the oral proceedings, to finally prepare the oral proceedings. Each of the judges is or any of the judges is asked to prepare him herself in advance to therefore, so everybody is supposed to be really into the subject of the case. And then during the oral proceedings, either the board interrupts for intermediate deliberation on certain points, so it is a step-by-step approach through the course of the oral proceedings or day of the oral proceedings. And before issuing the decision, there is again a final deliberation. And at that deliberation, depending upon the complexity of the case, that deliberation may take half an hour, it may take 2 hours, depending upon the case. And here the board, there's a secrecy of deliberation, therefore I cannot say what other boards do, and I cannot disclose anything what I did in certain cases, but the idea is to discuss the case point by point, and sometimes if it gets a bit tricky on certain issues, even to discuss the main lines of reasoning. Because as you said, the difficulty may be if you announce an order, appeal is dismissed, and while writing the decision later, the fully reasoned decision later, you should not become aware, oh, there's a break in the logic of the argument. Therefore, these are the points where we have in the past obtained a bit of experience how we can avoid that by a very fair and intensive deliberation during the oral proceedings.
Thank you very much. So same question to USDPO. So at the oral procedures, do you sometimes make the final decision at the time of the oral procedures?
No, we generally do not. It's possible that a panel may tell you how they're going to come out, but that would be the rare case. By statute, in our trial cases, we have to provide a final written decision. And typically, the cases are very large, as you know, and you've had many yourselves. We basically will go back after the oral hearing, deliberate, and then one of us will finally say, okay, sometimes we know which way we want to come out. Sometimes we say, we need to go back and look at the record yet again in light of all the commentary we received at the hearing. So even after, say, the hour or 2 hours after hearing, we don't always have a decision. We're going to go back through that record very carefully. And sometimes what a panelist will say is, I'm going to go ahead and write something up, I'll circulate it to you, and then we'll talk again. So it takes us time, and so we generally do not actually have an outcome. Now, our appellate cases, there are, again, rare cases where someone could say, this is the way we're going to come out at the end of a hearing, because they go in knowing a much more simpler record. They know that maybe the appellant's going to win. They've heard everything. They can tell the appellant, you've prevailed on this case. But again, that would be the odd case. It's very rare. Typically, they still want to have the judges confer afterward, although it's even a simpler record generally. There still may be some issues that they want to work out in the exact writing of how it's going to come out. So don't expect to hear at an oral hearing at our office a decision that day. It's going to take a little while.
So thank you very much. Same between some commonality between us, but thank you very much for your comments. So this is the end of the question number 1 or number 2. So Togashi-san, would you please go to the next question?
So we are now moving on to the question 2. Question 2 is about witness examination. The first item is question 2A. If examination of a witness is requested by one of the parties, can your office reject the request? How is the determination of whether to accept the request made? JPO Chief Judge, Mr. Morifuji, would you give us your answer? Well, for JPO, whether or not evidence will be taken as witness examination is to be determined ex officio by the panel. However, the panel, in principle, will not refuse to examine, assuming that the evidence may not be strong enough. When considering whether evidence via witness examination should be taken or not, the panel communicates with the parties as necessary. In some cases, the panel may encourage limitation or withdrawal of examination of a witness. For example, for several pieces of evidence, if the facts to be proved are considered to be the same, it is confirmed with the parties, and they may be asked to limit to the main evidence. So that's it from me. Thank you very much. Next, I would like to hear from USPTO Vice Chief Judge Dr. Tierney.
Yeah, this is a little more, it's a complicated question, but for ex parte appeal, there is no cross-examination, there's no examination of a witness. For our trials, there's different routes. If you've provided a declaration, for example, you put in an expert witness into the case, or your inventor was put in a declaration, automatically by statute in our inter partes reviews and post-grant reviews, you would be entitled to take cross-examination. We don't have any say in it. We have our rules to tell you how to do it, but you're entitled to take that cross-examination. However, if the witness you're seeking to try and get to testify is not someone who's already submitted a declaration, then it depends if it's a witness from the party itself or if it's a third-party witness, someone you need a subpoena. If you need a subpoena, basically either way, if you need a third party or it's being contested, the first hurdle you're going to have is called you have to show in the interest of justice that you need this cross-examination. And that's, again, a statutory requirement. So for an inter partes review, in the interest of justice, what that means, and we've interpreted it to be, there's a case called Garmin, and we have Garmin factors. To simplify it, generally what we look for is this going to provide relevant information as a first question? Is it something that you could generate by going somewhere else to get that information other than trying to get this discovery from this witness? Are you trying to learn someone else's litigation strategy? So let me just put an example out there. If you're going, and our cases are on validity, if you have some reason you want to know about a new product your competitor's putting out that doesn't have anything to do with validity, and you're seeking to do a deposition because wouldn't it be nice to know about the new product, we're not going to allow that deposition because that's not in the interest of justice. It's not going to be relevant to our trial. So again, as Dr. Bullock mentioned, Chief Judge Bullock, we basically have a much more limited discovery than the district courts. And so again, what we're looking for there is it necessary to our case, necessary in the interest of justice?
Okay, thank you very much. It's a bit different in Europe at the EPO. First of all, witness or the taking of evidence by hearing a witness is only one of the potential means of taking of evidence. There are others like hearing an expert, documentary evidence, inspection, whatever. Witnesses are important or can be important, a bit like in the US, only in inter partes cases, not in ex parte cases. Why is this? Because taking of evidence occurs only on facts. Therefore, it's not something that is that the taking of evidence is ordered ex officio by the board. It is always upon request of the party. And this is then the decisive point. If a fact is not contested, there's no need to take any evidence. If it's contested, then that party that wants to rely upon that contested piece of fact needs to request the taking of evidence by hearing a witness or by filing a written statement, affidavit, for example. And then if there is a need to take evidence by hearing a witness, then the board would issue a decision, an intermediate decision for the taking of evidence, outlining 2 points. First of all, who's the party who wants to rely upon it? That is the party that bears the burden of proof. That means if the proof is not given, at the end of the day, that party loses on that point. And secondly, the board makes an outline on the questions that a witness should be heard. So it's not an open discussion giving the floor to a witness. It is on specific questions. And then the board will start asking the questions, and the attorneys will enter in an exchange as well, or raising their questions as well. So it's a formalized process, but it is limited. Again, that's important for me. It's limited to facts.
Dr. Beckedos from EPO, thank you very much. So we'd like to move on to the next question.
So I would like to go on to the next questions. So when examining a witness, what is the process to be followed? Mr. Morifuji of JPO? When witnesses are offered, you must submit document. There are examination request form and examination details form. For the latter, you must make a list of examination items and also write the time needed for examination. And with examination, it will be direct examination, cross-examination, and redirect examination, exactly what we have done in the mock proceedings. And direct examination, in direct examination based on examination items which is written in the examination detail form, examination will be conducted regarding the items which have to be substantiated or related items. In cross-examination, the party who conducted direct examination and the party on the other side will examine on matters that appeared in the direct examination and matters related to, as well as on matters related to the credibility of the witness testimony. And Chief Administrative Judge may examine a witness oneself whenever one deems it necessary. So that is the... So, EPO, Dr. Beckett-Dolph, would you kindly answer to this?
Yes, thank you. I already mentioned that taking of evidence by hearing a witness requires a decision, intermediate decision by the board to do so. And then on the procedure, the board can decide whether this witness is to be heard before the board itself or whether the witness is heard before a court in the country of residence. And there might be good reasons for not forcing a witness to come to Germany, to Munich, to be heard, but that it's easier to hear that witness by a national judge. Secondly, if there are several witnesses, they are all heard one after the other. And the other witnesses must not be in the same room when the first witness or the other witnesses are heard, in order to avoid potential influence compromising the quality of the statement. Furthermore, on the formalities, the appearance of a witness may be subject to paying a certain fee in advance, covering the costs for that witness to appear before the court, transport, travel costs, or even a reimbursement of loss in salary or anything like that. This can be subject, or the hearing of a witness can be subject on that. The witness statement will be minuted in detail. The parties may not only raise, or the attorneys may not only raise their own questions after the board has finished, but they may also make an assessment on the witness's statement after the end of the hearing, so that it's a question of again, right to be heard. That's not only for the board, but also for that the parties get the choice to make their own statements about the quality and the relevance of what they heard from the witness. Thank you.
So our process is similar in JPO and EPO in that we have a lot of requirements. A lot of procedural requirements just to make sure that things move smoothly. Basically, for our system for depositions and cross-examination, we have an interesting way of doing our inter-parties review. As it was pointed out, we have a first initial phase where we see if we even have a trial. And if we have a trial, we institute, and then we move into the trial phase. It's within the trial phase that the vast majority of the depositions of cross-examination will occur. It's rare but possible that there may be some issues that we need pre-institution. For example, there's something called a one-year statutory bar. If you don't file within 1 year of being sued on a patent by the real party in interest or a privy, then you may not file and have it instituted. So if you're a year and a day and you file and you're a privy, you would not be able to go forward with an institution decision. So once in a while, pre-institution, we have to figure out, are you a privy? Are you related in some way to the person who had been sued previously? And we may get depositions of the witnesses from the company. Were they working with the person who was sued? Are they representing their interests? If they are, to what extent? Those depositions may be pre-institution, but the bulk of our depositions occur post-institution. And that's where we have the experts being cross-examined. For us, just to simplify it, Most of the depositions are going to occur at an attorney's office. The expert will show up, they'll be cross-examined. There's various rules on it. The key points for our rules are that you can file an objection. You just say object as an attorney. You don't then start talking and say, I object, it's not relevant, because that would be leading the witness. Because you could say, I object, the question is unclear, and you're telling the witness to go, oh, I don't know how to answer because your question's unclear. And all of a sudden it becomes more, the attorney is getting in between the witness and the person doing the cross-examination. So that's one thing we really try and tamp down on. If it becomes so onerous, shall we say, that the attorney's interjecting too much, or there's a question that they're instructing the witness not to answer, that's when they can call the board and have judges who will answer the question, does the witness need to answer or not? But that's very rare. We've made it streamlined, so the vast majority of the depositions occur at the office of an attorney. The questions are not, straightforward. They're not having the interjections, and we don't actually get involved. All we get is a deposition transcript at the end that goes into our record. So I think that should cover it.
Thank you very much, Vice Chief Judge Tierney of USPTO. Now, the next question. Question 2C. Are there any other matters that should be kept in mind when examining a witness? Chief Judge Morifuji of JPO, would you please answer? Thank you very much. Questions asked in witness examination need to be as specific and individualized as possible. It is important to keep it clear and straightforward. If a question is comprehensive or abstract and not a simple question and answer format, or the witness has to answer by telling a story, a judge will tell an examiner to ask in a different way. Also, prohibited questions are not accepted. For example, a question asking for a statement of opinion. In the hypothetical case mentioned earlier, if you ask to a witness, do you think that a person skilled in the art can recognize the issue of liquid leakage? It is regarded as a question asking for a statement of opinion, therefore regarded as a prohibited question. In any case, I think it is important to ask clearly, keeping in mind the facts you are trying to prove. That's all for my answer. Thank you very much. Next, from USPTO, Vice Chief Judge Tierney, please.
So, are there any other matters that should be kept in mind when examining a witness? I'd say the key point, realize you're creating a transcript that will be read by the judges. So one of the things you want to do is you want to highlight your key points. If something is important there, that's great. But in taking the examination, don't burden it down with unnecessary questions and just trying to badger a witness. The U.S. is a very adversarial system in some of the district courts, but we try and keep it much more professional and at our board. And so if we see a witness that we feel has been questioned improperly, that's something we may take note of. And those attorneys who are doing that tend to have a reputation that gets known within our office. And your credibility is very important. So we just want to make it clear that when you're dealing with a witness, be very professional. We understand there may be a lot at stake. You may not like the answers you're getting from the witness, but keep it professional and keep it polite.
Shall I wait a bit because the translation doesn't work? Does it work now?
Excuse me, please start.
Thank you very much. When it comes to that issue, apart from the fact that I just heard and that I can only subscribe, not repeating, the most important points of what we distinguish when hearing a witness and assessing a witness statement is that we distinguish between the credibility of a witness and the plausibility of the statement. Credibility refers to the relation of the witness to the party. It can be related to the party, can be an employee of one of the parties, can be otherwise having an interest in the outcome, to whatever extent in the outcome of the proceedings. This is something that is always established at the beginning with some questions at the beginning of a witness hearing, and the attorney of the other side will make us aware should there be any problem as well. When it comes to the plausibility of the answers, this is very important to have the case well prepared. As I said earlier, it is the board that asks the first questions, and the board should know what is needed as facts from the witness, not to get a specific outcome, but at least what are the relevant facts. And for this, the intermediate decision with the outlining the questions to the witness, this is very, very important. And yeah, that's it, apart from the fact that I already heard from the others. Thank you.
Thank you very much. So we have listened to the opinions from all three boards. So Morifuji-san, please. Thank you very much. So if there is a request for the examination of the witness, we have listened to the opinion from the three people in the first stage. And the second stage, we have asked if there are anything that we have to take into consideration. So I think the answers were very good. And also, thank you for your detailed explanation about what we have to take into your consideration. So I think time is rather limited, so I'd like to put the end to the question number 2, and I would like to go to the question number 3. Is it okay?